Alors, bon après-midi. Mon nom est Béatrice Noël. Je vais avoir le plaisir d'être votre maîtresse de cérémonie pour cet après-midi sur la scène Purple. Et on commence tout de suite avec une première conférence pour cet après-midi sur les nouveaux enjeux en matière de blocage et notification de contenus illicites sur Internet. Je veux laisser la place à nos conférenciers, donc je vous les présente dès maintenant. Nous avons la chance d'accueillir aujourd'hui sur cette scène Ryan DiAndrea, agent spécial, directeur national de programme, Centre national américain de coordination des droits de propriété intellectuelle, donc the Special Agent National Program Manager of the U.S. National Intellectual Property. Did I have it well? Property? Yes, thank you. Rights Coordination Center. We also have Daniel Pink, directeur principal droit d'auteur et bande passante pour Rogers. Then Monsieur Daniel Pink, Director of Copyright and Broadband. On va m'arrêter. Oh, nous n'avons pas de traduction en anglais, donc c'est juste français. Just in French. Ah! Ça veut dire s'ils ne comprennent pas l'anglais, c'est que du français, c'est ça? Alors, en ce moment, nous avons seulement la partie francophone, donc je peux voir ceux qui sourient et qui me comprennent. And I have the English people who say, what's she saying? We just have the French version for now, but it won't be long. We're going to have the English version translation in a minute or so. I'm waiting for the signal. OK, vous entendez? English people? We do? OK, just you? OK, several. Then we have the English and the French. Parfait, donc je refais la présentation. Re-bienvenue. Then the subject, le sujet pour cette conférence cet après-midi sera les nouveaux enjeux en matière de blocage et notification de contenus illicites sur Internet. Et pour la conversation, nous avons la chance d'avoir deux conférenciers hors pair, dont M. Ryan DiAndrea, Special Agent National Program Manager, U.S. National Intellectual Property Rights Coordination Center. And we do have Daniel Pink, Director of Copyright and Broadband. Donc, en français, nous avons donc M. Ryan DiAndrea, agent spécial, directeur national de programme, Centre national américain de coordination des droits de propriété intellectuelle. Et nous avons Daniel Pink, directeur principal, droit de l'auteur et bande passante pour Rogers. Et la conversation va être menée par nul autre que Olivia Bassin-Joffre, IP Law Anti-Piracy, Privacy Law at LeakID. LeakID, is that correct? Excellent. Nous allons avoir 45 minutes. On va essayer de garder une petite période de questions à la fin. Donc, gênez-vous pas. Gardez vos questions pour la fin. On aura le micro ici pour pouvoir adresser les questions à nos conférenciers. Sur ce, bonne conférence.
Can you all hear me? Wonderful. Bonjour à toutes et à tous. Je m'appelle Olivia Bassin-Joffre. Je suis responsable juridique et affaires publiques de l'INCYBER. L'INCYBER est la société française d'anti-piratage. Nous protégeons les contenus de nos clients partout dans le monde, que ce soit dans l'industrie culturelle, c'est-à-dire pour le cinéma, la musique, la presse, l'édition littéraire, mais également dans le sport. Nos clients sont par exemple les ligues principales de football en Europe. Pour en citer quelques-unes, la Première Ligue, la Serie A ou la Ligue de football professionnel en France. Nous menons des actions de déréférencement. Nous sommes les partenaires historiques de Google. Nous faisons de la détection de contenus live et non live, manuellement et de manière automatique. Et nous envoyons des notifications dès que nous trouvons ces contenus. Et nous avons développé des partenariats avec les plus grandes plateformes comme Meta, TikTok ou YouTube. Aujourd'hui, donc, j'ai le privilège d'intervenir avec Daniel et Ryan. Et par souci pour que nos échanges soient plus pratiques, I'm going to continue in English. We're going to talk about the situation in Canada, in France, and in Europe, and also in the United States. Daniel, the floor is yours.
Okay, thank you very much, Olivia, for that introduction, and thank you to the FIC for inviting me to speak today. Very excited to be here. I'm going to try the slide thing. Hey, there we are. Thanks everyone for coming today. My name is Daniel Pink. I'm the Director of Copyright and Broadband Policy at Rogers Communications. For those who are not familiar, Rogers is one of Canada's largest telecommunications company. We have a media division, we are a cable company, and we are an ISP. So In my day-to-day job, I primarily deal with content protection. I manage our content protection team at Rogers. But I also wear a policy hat for our broadband or internet service. So when it comes to site blocking, I'm constantly switching the hat and trying to manage two different priorities. Wanting to protect content and also ensuring that it doesn't cost us too much to implement. And that there's enough safeguards in place that we're not accidentally blocking content that is not illegal. So what I'll be doing during my time today is we're going to quickly talk about how we got to site blocking in Canada. We're going to talk a bit about the two different use cases we have in Canada right now for site blocking based on two legal precedents that we've set. And where we, if we have time, and I haven't been told where I'm out of time, I'll talk about a bit about what we're seeing come down the pipelines in terms of what we can expect within the Canadian site blocking landscape. So, when we started looking at content protection, it was roughly 6 years ago. And what we did to start off is we looked at what's happening globally in the content protection and blocking space. And we saw really the emergence of two different models. One is a model where you apply to an administrative tribunal, and the administrative tribunal, if you meet the factors that they've set out, they'll allow you to request certain websites be blocked. The others, it was a much more legislative approach where specific copyright acts will contain provisions that allow you to apply to courts and seek a site blocking order. From a content protection landscape, we preferred the administrative route primarily because it was going to be cheap and much more efficient to actually seek these types of site blocking orders. So we looked at, in the Canadian landscape, how could we implement something like this? And we have a regulator who likes to be very involved in all aspects of everything we do in the telecom space. It's called the CRTC in Canada. And so what we thought we would do is approach the CRTC. We formed a massive coalition, probably one of the few times everyone in the media landscape got together. There were over 25 organizations. And we put an application together to the CRTC, and we said, we'd like you to create a piracy review agency. And what this piracy review agency would do would adjudicate cases from rights holders. And if they felt that the piracy sites were, and I forget the exact wording we used, it was structurally overwhelmingly engaged in piracy, then we'd be able to block it. And the reason we had to go through the CRTC is because we have kind of a unique piece of legislation as part of our regulation that says that ISPs, or internet providers in Canada, are not allowed to do anything to control the content across our network. Net neutrality would be kind of what it's most commonly known as, but it's enshrined in our Telecom Act. So we were a bit worried that we would need the CRTC's consent in order to implement any blocking. For any Americans out there, if I mention the word SOPA, I'll see a few shudders, I'm sure. We didn't quite get that negative reaction, but it was a really intense, we didn't even get to the proceeding, but there were so many comments from everyone on all sides of the equation, whether they were pro-blocking or anti-blocking, that I think the CRTC got a bit spooked. And what they ended up doing before even having a proceeding is they said, listen, we're going to deny this application because... Testing, 1, 2. Can you hear me now? Can you hear me now? How about now? Hello? Hello?
Can you hear me? 1, 2, 1, 2.
Je parle en français. 1, 2, 1, 2. 1, 2, 1, 2.
How about now? How about now? How about now?
No.
I could shout, but I feel like that would interfere with...
Time for a tap dance show. All right, guys.
We're back? Hello, hello.
We've got some moves.
For the old-fashioned, we actually listen up in the front.
En français, est-ce que vous entendez bien? Pouces en l'air. Count 3 in English. You hear?
Hello, hello, hello.
It's not working. C'est encore le 3.
Can I yell? Do you want me to get up and to speak loudly?
You can try. Okay. What are you going to do?
Oh, but the French might not hear me.
Make sure that we don't lose time. Continue in English. He's going to speak loud. Just for a few minutes that we take care of the flow. Les personnes en français, vous continuez à écouter. Et pas parler du son.
I'll speak very loud. Can you hear me in the back? We're okay? Okay, so we were talking about the CRTC decided they were going to deny the application. The primary purpose for that was they said, well, in Canada, the Copyright Act, it's an all-encompassing act. And if you want to, any rights or remedies available under the Copyright Act, they have to be enshrined in that legislation. And if another piece of legislation like the Telecom Act wants to play in that sphere, oh, you can hear me now? Okay, I'll sit down. Then,
Thank you.
then you need like very explicit language in the act. So they passed it off, but they said, we admit piracy is a huge problem and you need to do something about it. Why don't you go talk to your legislators? They're actually working on a consultation to amend the Copyright Act, and they're going to amend the Broadcasting Act, and maybe you'll have better luck there. So 2019, that consultation process was already underway. We were quite well aware of that. We were meeting with MPs trying to pitch our changes to the legislation. And really, we had hoped the administrative route would go, didn't work, so we moved to kind of that legislative change. And so what we were really pitching was new ways to go after live piracy or streaming piracy. The last changes were in 2012. Did you lose me? The last changes were in 2012 in our amendment to our Copyright Act. And so that really addressed downloading, BitTorrent traffic. It didn't do anything for us streamers or for combating streaming piracy. So what we ended up doing was we made a bunch of consultations with the government. What we were looking to do and get added was provisions that would specifically allow us to seek injunctive relief against intermediaries, site blocking. Also, we wanted enhanced, maybe I shouldn't yell then.
You don't need to yell anymore.
Okay, I'll sit down again. No, I'll stand and I'll just stay here so we don't go back and forth.
You're just a bit too far for the microphone to catch up.
Okay, I'll sit back down.
It's working, it's working.
Okay, so, and then the other thing we really wanted was new.
On this side.
Yeah.
Is it better over here?
Just stay up. Just stay up for the end of the...
Okay, so then the other thing we wanted was we wanted enhanced provisions to kind of engage the RCMP. We heard about that a bit earlier today, or the police in general. We wanted the criminal provisions to be broadened to go after commercial piracy, which is really the focus of our efforts. The government released a bunch of consultation papers. They said, yes, piracy is a problem. We are going to study that. And it's 5 years later, and they still haven't studied it. So alas, legislation does not move as quick as we needed to when we heard that kind of earlier. So what we really decided to do is say, enough of this. Let's take matters into our own hand. We're going to see if we can, under the common law, go to court and apply to see if we can get our own type of site blocking order pursuant to the rules of equity, which is we plead the judge and we say, you have the power to do this, and please, please, please do it. There's no real reason why you can't do it, so why not do it? And so we identified a target. The target was called Gold TV. At the time, Gold TV was the most popular IPTV service in Canada. And the reason we chose them as our test subject was really because, one, we had no idea who was operating it. They were really good at hiding their identities. And two, all the content servers and infrastructure was all located outside of Canada. So we knew when we went to the judge, he was going to give us an injunction to shut them down, but we knew there was going to be no way we were going to be able to enforce that injunction. So we went back to the judge and said, listen, you gave us this injunction, but we can't do anything about it. We were able to ask him to say, why don't you require all the ISPs in Canada, or the major ones, to block the content? And what we did was, we called it a static blocking order, which specifically goes after the URLs or domains that were providing access to the Gold TV service. So the judge, even though the ISPs all hated us for it, they fought tooth and nail, but in the end, we were able to kind of convince the judge that we should get this type of relief. It's very slow to update, but it's still very powerful at shutting down kind of these IPTV services. It takes a long time to see the results, but what we saw was it was the most popular service, most traffic going to it, and all of a sudden it drops off. It's now like minimal amounts of traffic of people actually still using this service. Slow but effective in tackling certain types of piracy. Rogers, as a right holder, though, our interest is actually in live sports. We're the rights holders for the NHL content, the national games for NHL. And for us Americans, it would be your football. For your Europeans, it's your football. But imagine having the power to control and try to sell subscriptions to that content. It is the crown jewel of what we own. But a static order is not going to work because we don't actually know where the content's going to air or where we're going to have to block until the game actually starts. So working very closely with a vendor based in the UK called FriendMTS, we collected the evidence we needed to kind of build the case to get a more dynamic site blocking order or a live event site blocking order, which we were able to get for the playoffs last year and will hopefully be renewing this year for the NHL season. And what it does is from the start of a game to the end of the game, it requires all the ISPs to block an updating list of IP addresses. And the IP addresses are the source of the illegal streams. So it's not actually effective at shutting down the piracy, but what it's very effective at doing is preventing people from accessing the piracy. And it's such a frustrating experience for users that the end goal there is to hopefully convert them back to paying subscriptions. So very briefly, I thought I'd just walk you through how it actually works. We have a fingerprint, so it's an invisible image that we put on our live feeds. And our vendor, FriendMTS, they scour the internet and look for open webs, so websites that are airing the games, closed IPTV services. And what they do is they generate a list of all the sources for these piracy that are showing our game. And then we run it through a list of criteria that's been approved by the court. And for all the IP addresses that meet the list of pre-approved criteria from the court, we then disseminate that list to all the ISPs in Canada, and they're forced to block it from the start of the game to the end of the game. It's dynamic in the sense that we can update that list in 5-minute increments. So at Rogers, every 5 minutes, we're ingesting a new list of IP addresses that allow us to block it. And when it's done properly, what you see is, and this is data traffic over time, traffic as the games start approaching, slowly peaking, and then the second we implement it, all the traffic going to those IP addresses instantaneously disappears like magic. And then after the game ends, you see the traffic go back up, and it peaks. This is the first 2 nights that we implemented it. As the season or the playoffs went on, you'd see these peaks start growing and growing as we're able to find more sources of piracy. And I have 2 children that are 2 and 5. And I've had this now, like I've been working on this for 6 years, so I consider this to be like my oldest child, and one of my great accomplishments is actually finally being able to see this happen in Canada. It's a labor of love, I would call it. So with that, I'm going to pass it over to Olivia. I guess you don't need this.
Can you all hear? Yeah? Good. So, like I said, at LeakID, we detect content and then we send notices and takedown. So, you can't hear me? You
have to have headset.
Can you hear me now? Good? All right. So, yeah, like I said, at LeakID, we detect content and then we send notices and takedown. So what I'm going to do is that I'm going to walk you through, in practice, how we handle the format of our notices and takedown with the current French law. Then I'm going to talk about the new anti-piracy bill that came into force in January 2022. And finally, we're going to talk about the DSA. So The legal framework right now relies on Article 14 of the e-commerce directive, which creates a safe harbor for hosting providers and ISPs. They don't have an obligation to monitor content. I usually call them the three little monkeys. They don't see, they don't hear, and they don't speak. And they can't be held liable as long as they don't know about the presence of illicit content. So how do we bring this information to their attention? For our notices and takedowns to be as efficient as possible, we rely on both the DMCA and the French law, Loi pour la confiance dans l'économie numérique, the LCEN. But you'll see they require different things, so it's complicated. It's rather complex to draft these notices. So DMCA requires that the notification includes the following information: signature of the person authorized to act on behalf of the owner of rights, identification of infringed copyright work, identification of the material claimed to be infringing said rights, information reasonably sufficient for hosting providers to locate said content, contact information of the right holder, and finally, a statement of good faith. So we address that, but then also there is the French law with Article 615 of the LCN, which states that for a notice to be valid, it must include the following information. And that's where it gets tricky. So first, date of the notification. Okay. ID of the complaining party. All right. Name of the infringing party. We can do that. Then facts description and the exact location of the illicit content. Okay. Then reason why said content must be taken down with the legal basis and justifications. So let me tell you, before sports right holders had any right in code, that was rather difficult to do, but we did it. And finally, reason why said content must be taken down, and then a copy of the notice sent to the publisher of the pirate site or to the author of the unauthorized content to request the removal of the illicit content, or proof that it was impossible to contact them. Well, that's tough. That's rather impossible to do. So it's a challenge. I mean, how can you do that? Especially now with live content, and you need to be very reactive. It's difficult. But then, until January 1st, since there were no legal dispositions to protect sports content, it was, like I said, difficult to draft these notices. That is why France passed the new anti-piracy bill last year, and it came into force on January 1st. I'm going to present the highlights of this new legislation. First, it created the merger between Hadopi, the High Authority for the Dissemination of Works and the Protection of Rights on the Internet, and the CSA, the French Audiovisual Council. And it created a new authority called the ARCOM, which is the Regulatory Authority for Audiovisual and Digital Communication, and it's been given new prerogatives to tackle piracy. Such prerogatives include the drafting of a blacklist of massive infringing sites. This is part of the follow the money approach, which tends to involve the online payment actors as well as advertising agencies. This blacklist will be integrated into the voluntary agreements, the so-called memorandums of understanding, concluded with said actors, and will point the fingers at those who actually still get involved with the bad guys. And then what's really, what we do now in the company is that this new law created dynamic judicial procedure for the blocking, removal, or delisting of sites offering pirated sports content. It created a new article, L 333-10, in the French Sports Code, which has become a game changer. Now, sports right holders, professional leagues, or audiovisual communication companies that have acquired exclusive rights to sports competition can ask the judge to stop the illicit communication to the public of pirated sports content and to prevent a new serious and irremediable infringement of these same rights. The infringement is characterized by the finding of serious and repeated infringements of their rights. But the thing is that we're only talking about DNS blocking, which is not highly satisfactory. So the judge orders French ISPs to prevent internet users located on French territory from accessing services that offer pirated sports content for the duration of the competition up to a maximum of 12 months. So then, as soon as the order is over, they have to go before the judge again. And what's new is that when a plaintiff notices the appearance of services offering pirated sports content not covered by the order, or if they discover mirror sites, they can refer the matter to the ARCOM, the new authority I mentioned earlier, which, after verification, forwards the details of such new websites to the French ISPs so that it extends the blocking order. So far, this new law has proved to be efficient, and we have accompanied the French LFP, the Ligue de Football Professionnel, on two occasions, which have been proven successful. And ARCOM has recently published a Médiamétrie study which showed that the global audience of unauthorized sports live streaming has decreased by 49% since the law came into force. However, DNS blocking can easily circumvented by changing DNS or by using VPNs. That is why we need to push the legislation to go beyond DNS blocking and eventually finally get IP blocking orders. Because we believe that IP blocking would be more efficient by tackling the root of the problem. And that is why we all expected a lot from the Digital Services Act, which was published at the official journal of the EU on October 27th. But the safe harbor benefiting the ISPs hasn't been touched. And now, so they remain these three little monkeys, and now Article 16 from the DSA requires providers of hosting services to put mechanisms in place to facilitate the submission of those notices and takedowns. That's what we got. So in theory, it will harmonize the content of notices and takedowns. The format should more or less match the DMCA's. So a sufficiently substantiated explanation of the reason why the content is unauthorized, the exact location of said content, contact information of the entity submitting the notice, and a good faith statement. But the biggest change is that now providers of hosting services will have to respond. Because before that, remember the three little monkeys? It was hard to get in touch with them, or dare I say, get a response. So now they're supposed to respond, so we'll see how it goes. But in practice, we don't think it's going to change a thing. For example, how will they appreciate whether the explanations are sufficiently substantiated? I mean, so it will still be in their hands. We can do as much as we can, but... And finally, although rights holders expected a European regulation on live sports piracy, I must say we're a bit disappointed, because it seems like the European Union has decided otherwise by deciding to only issue a recommendation on the subject. We were expecting a regulation. We get a recommendation, starts the same, RE, but not the same consequences. So, but that's what was written in the work program they just published. Perhaps it's going to change. We'll see. But so far, this recommendation should include a toolbox to tackle live sports piracy. We don't know yet what this toolbox is going to include, but we're here to see everything. So in conclusion, I'd say that piracy still has a long way to go, and that we must pursue our efforts to defeat it. And I'm going to leave my friend Ryan present the US model. Thank you.
Good afternoon. Can you guys hear me on the headphones? Fantastic. If not, I'm a New Yorker that's also Italian, so I have no problem getting up and speaking loudly. So if you can't hear me, start flailing and I'll get up and start yelling at everybody. So good afternoon. Thank you guys for the introduction. My name is Ryan DeAndre. I'm a National Program Manager and a Special Agent based out of the National Intellectual Property Rights Coordination Center. I'm an HSI, Homeland Security Investigations Special Agent. And I've been with the agency for a little while now. I just got over to the IPR Center about 2 months ago. Prior to that, I did cyber investigations in Baltimore. Later on in the presentation, I'll have some case examples of when I was an agent in Baltimore of some website takedowns that were successful. And then just a few months ago, transferred up to the IPR Center. So HSI is probably one of the largest reaching, as far as jurisdiction goes, federal agencies in the United States. We're also probably the biggest investigative agency that nobody has heard of, unfortunately. It's because we don't have one of those big flashy TV shows that is out on NBC or CBS, but we do have one coming. So I think everybody's going to know what HSI is, mostly HSI Puerto Rico, but it's a good start. We investigate cross-border anything that crosses the border, basically. So whether that is traditional goods that are crossing the border, whether it's narcotics, but it also spans into the digital border as well. So if we have crimes such as intellectual property theft of digital media, we investigate that also. These are just some stats from just the previous year. Actually, I'm sorry, from 2021. Our 2022 stats did just come out, but they haven't been finalized yet. So I can't use them in the presentation, but this just gives you an idea of some of the wide-ranging areas that we as HSI special agents investigate, prosecute, and seize. You can see we seized 50 website domains back in 2021. And over almost $1 billion in assets and currency that was seized just in 1 year. So we operate globally. A lot of people may not realize this, but HSI has a total of 10,000 employees globally, with about 7,000 special agents based around the globe. We have offices in 51 countries, and we operate out of about 200 cities in the United States. So we really operate on a global footprint. We have partners all over. And you can see here, these are some of the partners that we just have at the IPR Center. We have approximately 30 partners right now, private industry, governments, and it really allows us to engage and share information and to effectively police in this modern era. Without any of these partnerships, we wouldn't be able to get the job accomplished that we do. And these partnerships allow us to share information back and forth. So we will receive information from rights holders that is notifying us of whether it's an infringing domain that's publicizing their information, or a company like Pfizer, where they have interest during the pandemic, obviously, in COVID-related medications, and individuals that are trying to fraudulently sell, counterfeit, or just steal people's money through the utilization of their intellectual property through their copyrighted materials. And these are just some of the programmatic areas that we cover at the IPR Center. I cover digital piracy as well as tobacco, but you can see it's wide-ranging. We cover everything from physical goods that are being imported into the United States, as well as exported from the United States. We investigate pharmaceuticals, we investigate medical devices. It's a very wide-ranging purview that we have at the IPR Center as well as HSI. So how do we go about seizing a website as Homeland Security investigations? What we'll do is we'll receive the information from a rights holder, or we'll actually build it up from the start. if we become aware of it before we receive a lead from rights holders. We'll then take that information and we'll send it over to some of our partners that are able to take that information and enrich it. They're able to do some background investigations, gather intelligence, and build a package for us at the IPR Center that we can then take and push out to our field agents. So we don't directly run an investigation from the IPR Center. Even though I'm still a special agent, I don't physically work cases. I take information, package it up, build it, and then send it to our field agents where they then take that, present it to their local prosecutors, and they can then run a criminal case and their investigation from a field office. So we'll try and find jurisdiction in a city in the United States and find the appropriate agent to work that in that local field office and pass it on to them. So some of the things that we found in previous examples that have been very beneficial to us is it's important to establish a relationship with your local prosecutor and your local judges, because IP crimes and digital crimes these days are very complex, and the layperson may not understand why it's important and what it actually is at the end of the day. When you start talking to them in these highly technical terms, they may just get disinterested and not be able to bring that case to prosecution. So what we try to do is develop relationships, foster a relationship with the rights holders, with the prosecutors, with the judges, and then that allows us to, build these better cases. So when we actually physically seize a website, we are utilizing United States law, and it allows us to actually seize a domain name. We're not actually seizing a server on a lot of these cases, but we'll actually seize the domain name, and then we direct the TLD, the top-level domain, to then forward or to redirect the servers to a server that's, or redirect the domain to the servers that are controlled by Homeland Security Investigations, based out of our partner, the NCFTA, and they then will show this banner here on a seized website. This website banner here, I believe, has been viewed close to 100 million times just in the past year alone. So it really shows this impact that we can have by seizing a domain, even if that seizure may not result in an arrest of an individual or a civil penalty that's assessed. So some examples of website seizures that we had recently, and obviously with the pandemic, we have to be able to pivot and redirect some of our intellectual property investigations. So these next 3 case examples I have here are examples of cases that I personally worked and was able to seize domain names and have them redirected to the HSI server. So this first one is a website that was remdesivirmx.com. So the website actually claimed to offer medications for sale in Mexico. They claimed that they were a distributor that was authorized by Gilead Sciences. And you'll see on the next slide here what the address of the office that they claim to be working out of actually was. And I'm pretty sure it's not an actual Gilead Sciences laboratory. If it is, it's a little scary. But we worked up the investigation. We were able to write a seizure warrant for the domain, and then we presented that case to the local prosecutors, to the judge. The judge signed off on the warrant, and then we were able to send the seizure warrant over to the top-level domain, which in this case was VeriSign. So establishing a relationship with these companies also allows us to have better time to action with these seizures. So with things where you have people that might be selling counterfeit medications or something like that, it's important that we're able to have this quick time to action and able to get these sites taken down in an expeditious manner. And having that relationship that we're able to establish with our partners allows us to do that in a much faster manner than if we were to just start from the bottom level. So this is a snapshot of what the website looked like. Looks like a very professional website. They actually stole these images from the legitimate website. But this is the office that they claimed was their address in Mexico, which is obviously not a Gilead Sciences building. Another example is these 2 websites that were also operating, and they stole source code, they stole images, and they stole all types of intellectual property from Regeneron's legitimate website. Same type of example where we worked up the case the same way, reached out to the rights holders. They verified for us that that this website was in fact a counterfeit website. They weren't actually offering any physical items for sale. It was just a fraudulent website. And you can see here, it's basically a carbon copy of the legitimate Regeneron website where they just photoshopped a very poorly done logo to make people believe that they're actually getting legitimate pharmaceuticals. And then another website, freevaccinecovax.org, purported to offer vaccines for sale to the general public. I'm sorry, not for sale, but for free to the general public. And it actually turned out that this website was being operated, I believe, out of Lithuania, but it was actually a Russian domain that when you went there and you entered in your information in the site to get your free vaccine, you would all of a sudden see that in the background of the web page there was a PDF that was generated and sent to a server that was in Cyrillic language and sent to a server in Russia. So this was a phishing website that purported to be a legitimate Regeneron website, which was actually sending information to a server in Russia, stealing people's information, their private information, their social security numbers, and that type of stuff there. So, we lost me? Well, I'm done, so that's good. And this here is just an example of the PDF that was generated in the background, and then the actual website. They had the WHO's logo on there, they had the Pfizer logo, and the UN logo on there as well. And here's my contact information. If anyone has any questions, feel free to get with me afterwards, because I think we are out of time.
Ça marche ou pas? Does it work? Can you hear me? Okay.
Je vais laisser le mot de la fin à Olivia. 45 secondes pour le mot de la fin. 45 seconds for the guys to wrap it up.
All right. Thank you very much. I'd like to thank my colleagues here. As you see, piracy has bright days ahead, and that's why we need to team up. And that's why we need to use all the tools, no pun intended, that exist. We need to be creative to tackle piracy. And that's why events like FIC are so important, because they're a great opportunity to meet other people and build bridges so we can all team up together. Thank you very much.
Alors, un grand merci à nos panélistes, à Olivia. Je vous rappelle que nous allons avoir une prochaine conférence sur la scène Purple à 3h45. Prochaine conférence sur la scène Purple at 3:45 for the next one. Enjoy the rest of the forum.